Thank you very much. I will now call the case of State of Kansas versus Kyle Scott, case number 125384. Counsel, you may approach. Van Houten, when you're ready.
Good morning, Your Honors. May it please the court. Again, Darby Van Houten of the Appellate Defender's Office on behalf of Kyle Scott. This is a straightforward case with a single issue in front of this court on appeal. That issue being that the district court erred when it wholly misunderstood and misapplied the law at Mr. Scott's sentencing by failing to recognize the statutorily defined mitigating circumstance of a lack of a criminal history. For some background, Mr. Scott was convicted of 2 off-grid Jessica's Law offenses, and at and ahead of sentencing, he filed a motion for departure, listing several mitigating factors in support of that motion and request. This included his employment history, one-time nature of his offense, support of his family, low risk of recidivism, amenability to treatment, and his lack of criminal history. Again, he had no criminal history. His PSI listed nothing. He was criminal history I. KSA 216627, specifically sections D2 of that statute, set forth mitigating factors for courts to consider in reviewing a departure request in a Jessica's Law case. Statutorily defined mitigating circumstances. That list is not exhaustive or exclusive, but it does list circumstances that are mitigating per se under the statute. And one of those is the defendant has no significant history or prior criminal activity. These factors, if established, must factor into a district court's decision on whether or not to deny or grant a departure request in a Jessica's Law case. When considering Mr. Scott's departure request in this case, the district court made a mistake. It said that a lack of criminal history is not a mitigating circumstance. The district court didn't just say, it is a mitigating circumstance, but I don't find it substantial and compelling. The district court said it's not a mitigating circumstance and dismissed it. This is an error of law. An error of law is an abuse of discretion and reversible by this court. And I can potentially see how the district court can make a mistake like this, although it's still a mistake. The statute that controls mitigating circumstances and departures in non-Jessica's Law cases doesn't list lack of criminal history. Those are probably more frequently seen in district court, but this is a different case. This is a Jessica's Law case. And there is a statute that specifically lists factors that are mitigating, one of those being a lack of criminal history. The district court dismissing that lack of criminal history as non-mitigating, again, is an error of law. The state argued in their briefing before the Court of Appeals that judges can determine if something is a mitigating factor. That is not true, especially in this case, again, because the mitigating factors are statutorily defined. The district court in this case disregarded and misapplied that law. A district court applying the correct legal framework, using the correct legal framework in a case, would and must have given that factor more weight.
The way the district court judge worded what's happening here, you can squint one way and see it, and squint another way and see it. Let's get past that. Let's assume it's error. Why is it not still harmless?
I believe it's comparable.
These are bad facts from a crime standpoint. So why would we say that there's no judge out there that would have granted this departure motion under these facts?
Because, Your Honor, and if you're going to get to harmlessness, I would say my position is that because it's an error of law, it's an abuse of discretion and reversible. It must be reversed.
Still has to be harm. There still has to be harm.
If you're getting to the harmlessness, I don't believe the state can prove that it was harmless in this case. And that's because, in borrowing the language that this court used in Randolph, and that's 297 Can 320 from 2013, there's a reasonable probability that use of the correct legal standards could affect the outcome of the departure motion. If the district court had been using the correct legal framework, they could and must have reached a different decision. They must have given it some weight. That was something they had to do and didn't do. Again, it would be different if the court had said, it's mitigating, but it's not substantial and compelling. That's fine. That would be a different question. Perhaps we'd have an appeal that that's an abuse of discretion, but not based on an error of law. This is an error of law. There was one factor in this case that the district court found substantial and compelling, and that was amenability to treatment. Just like in Randolph, I believe a district court seeing and using not just one mitigating factor, but two at least, would have reached a different decision. That's why I believe it's reversible and the state cannot prove harmlessness. Again, when the district court's decision is based on an error of law, the district court abuses its discretion and reversal is necessary. That's why we're asking this court to reverse the Court of Appeals, vacate Mr. Scott's sentence, and remand to the district court with orders for resentencing. I'd stand for any other questions that this court has, if they have any right now.
Earlier on, the district court judge does state the standard correctly, correct? I mean, early on discusses the controlling statute, listing, the identification of mitigating circumstances and the weighing. It's just then later on in the application, the finding is that it's not a valid mitigating circumstance. What do we make of the fact, if anything, that at least we know at the outset, the district court judge articulated the correct legal standard?
I would say that's great that the district court said it at one point, but in applying it and actually making the decision, it did not apply that law. If it had been applying that correct legal framework, it would have said and decided it is a mitigating circumstance. I recognize that, but it's not substantially compelling and I'm going to deny your departure request. And again, I think you can see that in the language that the court uses later, as Your Honor is referencing. In considering the other factors, the court said those aren't mitigating, and that's fine. Those aren't statutorily defined mitigating circumstances. Lack of criminal history is. If there are no other questions, I'll rest right now.
Any other
Back to
questions?
rebuttal.
Thank you.
Thank you.
Ms. Lithkin.
Good morning, may it please the court. Jody Litvin on behalf of the state. Our position, of course, is that the district court here correctly correctly considered the mitigating circumstances in this case and properly denied them, and that there was no abuse of discretion either in an error of law or on the reasonableness. From the outset, the judge said, I'm considering at this point the following mitigating circumstances that have been alleged, like Your Honor was saying. So he does, from the get-go, acknowledge that there are, I think, 6 is what the district court ends up going through, although I think there was 4 in his new attorney's motion for departure and maybe 2 from another that carried over. So we think that although the district court did use the language, I mean, I'm not disputing the language that said this is not really a valid mitigating circumstance when they were talking about criminal history. But I think if we read it all in context, the judge said, I'm considering all of these mitigating circumstances. I find one to be substantial and compelling, but I find one to be valid and I'm not finding them to be substantial and compelling overall. So our position is that the district court properly considered these and that the Court of Appeals opinion affirming the district court's consideration of these departure factors should be affirmed. I don't know that I have really any further presentation other than, just to take it all in context and basically what we briefed below, just to say that this was a proper consideration. This was a statutory mitigating factor that the court did take into consideration.
Counsel, does your briefing below include any discussion of what the remedy would be for an error? Is there a harmlessness analysis?
Yeah, I don't know that there was a specific harmlessness analysis here. I think the way that the state briefed it, the way that I briefed it was, this wasn't an error of law, and then moved on into this also wasn't an unreasonable, for the other part of an abuse of discretion. So I didn't call it harmlessness, but it was just as far as the 2 reasons that they were saying that this was an abuse of discretion. 1, it wasn't an error of law, and 2, no other, you could find a reasonable person to agree with what the district court did here. So it was harmlessness in that way, but not really a true, I guess, way that I would brief harmlessness in other issues. If-
But I mean, it is the state's burden to establish harmlessness if we get to that point. But are you suggesting that we can look at the record as a whole and kind of dovetail the argument about reasonableness into a harmless error analysis?
Yes, I think that's what I'm arguing. Yes, Your Honor.
Thank you.
Although it's short, I don't know that I have anything further to present to the court.
Colleagues, any other questions or follow-up? Thank you, Ms. Lipka.
Thank you.
You reserve 4 minutes.
Thank you, Your Honors. Again, I would just highlight that I believe the state is misunderstanding this issue. It seems that they're saying again that this is not an error of law. It clearly is. They've acquiesced what the district court said, the language the district court used, even reading it in context, as Your Honors are able to. It is clearly an error of law.
Do you think that this district court judge truly believed that lack of criminal history is not a lawful mitigating circumstance?
Based on the record, yes, Your Honor.
I mean, that's a pretty wooden reading of the language.
If it is wooden.
Well, I guess what I'm asking is, you're making a strident case. You're being zealous on behalf of your client, but it seems like, I guess the question is, are you willing to concede that the language in the record might be ambiguous, might be able to be read 2 different ways? Because you seem to suggest, no, it can only be read one way.
Yes, I'm saying it can be read one way. And the exact language, as I believe you're referencing, Your Honor, is I don't find that it is really a valid mitigating circumstance in this particular case.
Right, and why couldn't that be read to mean, well, yes, of course, it's legally a mitigating circumstance, but in this case, I don't find it to be compelling.
That's what the district court should have said and should have
I know,
applied.
but why can't the language that's in the record be read to mean that?
I believe because of the entire sentence, the entire context. Although the state is believing that the entire context means the opposite, I believe the entire context shows that the district court misunderstood the law, misapplied it. Although the language at the end of that sentence, I believe, is what Your Honor is referencing. The whole sentence matters. The fact that the court specifically says that is not a valid mitigating circumstance, that is just incorrect. That is not true. It
Right.
is.
That's a pretty sentencing 101 question, wouldn't you agree?
Yes, Your Honor.
And wouldn't that suggest that it would be remarkable for a district court judge to make that error?
I mentioned earlier, and in going over this case and practicing in front of district courts myself, I don't think it is remarkable, but I think it's because district courts don't see Jessica's Law cases as often as they see non-Jessica's Law cases. That's what's in front of them every day. And that statute, I concede, the non-Jessica's Law one does not list lack of criminal history as a mitigating circumstance. It's baked into the grid. But that's not what's happening here. It's a mistake, an understandable one, but a mistake and an error of law.
Thank you. Any other questions, Colin? Thank you very much for
Thank
your
you, Your
arguments
Honors.
this morning. Court will be in recess until 10:30, and we will call our 10:30 docket at that time.